So good morning, everyone, and welcome to this fourth panel on process and prospects. So my name is Niall Moran, and I am Assistant Professor of Economic Law at Dublin City University at the School of Law and Government. So this panel will close off what has been a very enjoyable and stimulating 2 days of discussion on the various elements of the Trade and Cooperation Agreement that form the subject of this forthcoming book, The Law Politics of Brexit, Volume 5, the Trade and Cooperation Agreement with Oxford University Press. So I think this panel, it's a good follow-up to the one we've already had this morning. I learned a lot about fisheries, transport and aviation. And we're going to have more discussion here on expiration dates, treaty revisions, but also perhaps more of a big picture view of the TCA, perhaps more in the second talk we're going to have. So the theme for this panel is process and prospects. And we have two very distinguished speakers who happen to be my close colleagues and friends at the DCU Brexit Institute. Christy will be speaking about regulatory cooperation, social security coordination, and participation in union programmes. And Federico will be speaking about review and reform, options for deepening EU-UK cooperation in a renewed Europe. So in keeping with the normal format, each speaker will have 15 minutes to present their paper. And at the end of each panel, we will have a Q&A session. So I've read both of these papers. They're two very interesting and challenging pieces. So I'm really looking forward to these presentations. If you have a question for either speaker, you can post it in the chat. You can send it to me directly or simply raise your hand when the Q&A session begins. Okay, so I think we can begin. Our first speaker, Christy Petit, she is Assistant Professor at the School of Law and Government at DCU and Deputy Director of the DCU Brexit Institute. She was a Research Associate for 2 years at the Florence School of Banking and Finance at the EUI. Her research interests cover EU law, financial supervision and regulation, the law of the banking union, the economic and monetary union, and central banking. She defended her PhD thesis on an integrated system for banking supervision in the banking union at the EUI Law Department. She's a graduate of the College of Europe and has interned at the ECB and at the Court of Justice of the European Union. Christy, whenever you're ready, the floor is yours.
Thank you. Thank you very much, Niall, and thanks so much for this invitation to present. So I wrote a chapter indeed on regulatory cooperation, social security coordination, and participation in union program. So 2023 has been quite a year of transformation as regards the UK-EU relationships, and they have been reactivated, and this paved the way for closer regulatory cooperation, at least in the financial services area, and to some extent for cooperation in research. Actually, in the political declaration attached to the TCA, it foresees the establishment of frameworks for voluntary regulatory cooperation in areas of mutual interest, including exchange of information and the sharing of best practice. However, as was discussed yesterday and as it was covered and extensively documented in the former volumes of the Law and Politics of Brexit, the implementation of the Northern Ireland and Northern Ireland Protocol delayed the adoption and also the implementation of some of the concrete arrangements that were foreseen in the sources themselves of the treaties. So in the fields of financial services, education, research programs, and social security coordination, the TCA governs the UK-EU relations post-Brexit with some looser requirements as they were inserted in draft protocols yet to be adopted, and in the case of financial services, and a memorandum of understanding yet to be implemented. So with all those sort of surrounding elements, this requires strong political will to put those commitments into concrete actions. So in this paper, I examine the status of regulatory cooperation following the Windsor Framework Agreement and the reactivation of the EU-UK relations. So I will guide you through some of my findings, first for financial services regulatory cooperation, then the UK's participations in union programs, secondly, and third and last, I will finish with a few words about the framework for social security coordination. Regarding the UK-EU regulatory cooperation in financial services, I will set the scene a little bit because the TCA includes only very few provisions. There is no financial services chapter per se, as we could expect, perhaps because in other trade agreement we could find it with other third parties. here it has a joint declaration on financial services regulatory cooperation that referred to a future memorandum of understanding. And actually, the technical negotiation for this MOU, this is the abbreviation in short, were done quite at another stage, and by the date that was set there in the joint declaration, namely March 2021, but it was blocked as once again linked with the situation in Northern Ireland, with the protocol in Ireland and Northern Ireland. But this year it was approved politically in May finally and signed in June. So some of the key takeaways we can observe from the MOU itself and the upcoming joint regulatory forum here. First, it is a framework for structured regulatory cooperation in financial services. It is quite detailed and extends the joint declaration, which is on the contrary very short. This regulatory cooperation is framed, of course, at the technical level. You will find some very standard provision for exchanges of views and information, some best practices, the regulatory development and issues of common interest in the field of financial services, market developments, stressing financial stability issues for the two counterparts, dialogue on equivalence decisions, which was one of the big issues on the way to the joint declaration itself, and enhanced cooperation and coordination at international level. But I will get back to this point of the international level. What we need to take away from this MOU is that it's a non-binding document. It has a non-legally binding nature as other cooperation frameworks, so it contains only some shared commitments that are of a voluntary nature. Therefore, if we look at the joint regulatory forum that is expected to take place very soon. Actually, the first should take place in autumn. There are a few objectives that are very common as regard transparency and certainty provided to the parties, and making sure that the EU and the UK are aware of some cross-border issues in the field, that they develop compatible standards at bilateral level, and then implement international standards consistently. What I want to signal here is that this joint regulatory forum is, of course, outside the TCA committees and the specialized committees that exist and provided for under Article 352 of the TCA. So if we look at the practices yet to be observed, so here I will just share some very general observation. Considering what is done with other countries, we can expect that the forum will exchange on the latest developments in banking and insurance, digital and sustainable finance, and other matters. So this is very similar to a stock-taking exercise and helping the parties to meet and exchange on emerging risk and emerging and future risks to markets. But here, to finish very shortly, very briefly on this aspect of financial services regulatory cooperation, there is a layer that is very important to keep in mind. It's the role of international cooperation. So this is perhaps one exception to what Professor Fahy depicted yesterday. In Article 186 of the TCA, the EU and the UK are to make their best endeavors to ensure that internationally agreed standards in the financial services sector for regulation and supervision, for the fight against money laundering and terrorist financing, and for the fight against tax evasion and avoidance are implemented and applied in their territory. So this is something very important because it sets out some international cooperation fitting into the bilateral cooperation they have. So the MOU, on top of what we find in the provision of the TCA, is inviting the EU and the UK to coordinate their positions ahead of international meetings. So this is one element proving a closer regulatory cooperation in this field between the EU and the UK. Okay, moving on to the second point, which will be a little bit shorter, that concerns the UK participation in union programs. At the beginning of this month, the EU and the UK reached actually a political agreement on the association of the UK to Horizon Europe and Copernicus. Pretty sure that you're aware of it. But before that, it was frozen for some time. The UK-based universities have exited from the EU programs and networks such as Horizon Europe. So what happens is that legally, Article 710 of the TCA stipulated that the UK should participate in new programs, but that was on hold for a while, again, for the broader political context. A joint declaration on participation in union program and access to program services was published alongside the TCA and referred to yet to be adopted protocols 1 and 2. Protocol 1 on programs and activities in which the UK participates, and on the other hand, Protocol 2 on the access of the UK to certain services provided under union programs and activities. So there were some hiccups, not only the political context, but also the pending adoption of some legal instruments underpinning the union programs and the multi-annual financial framework. I will not delve into the details, but it means that in the meantime, the UK could benefit only from a very limited set of EU programs that work independently from Horizon Europe. And there were some interim funding programs adopted at domestic level to sort of cater with the unfortunate situation. The only development that happened before September 2023, it's the participation in the Peace Plus program from January 2020. So the Windsor Framework Agreement raised hopes. There were lots of declarations by different leaders. And from this month, this political agreement is paving the way for the UK to participate in EU programs such as Horizon Europe, and it will associate itself as of September. So this means that UK research institution can be involved in the remainder years, 2024 until 2027. So this led to some financial arrangements. Beside that, 2 other union programs are now open to the UK as well. So Copernicus, that gives access to capacity for monitoring the Earth. And second, the EU space surveillance and tracking services allowed to monitor and track the space. So these were also part of this deal reached at the beginning of the month. However, if we look at the scope of UK participation in union programs, it's slightly reduced if we compare with the draft protocols, because the Euratom program was dropped, also the International IT Year Fusion Project. And if we observe the development at domestic level, the UK favored its own nuclear research and development under the UK fusion strategy. So the scope is a little bit different. I'm pretty sure that in this circle, most of you are aware, but I just wanted to signal that in terms of governance, now that the UK has its participation reactivated, it will contribute to the governance of the EU programs or activities it joined, but as an associated country in most programs. So it means involvement, but no formal decision-making powers. It has the status of a close observer without any voting rights, but the knowledge of the result of the vote. And last but not least, as regards social security coordination, that was a little bit more difficult for me. I have a notion, and this is what I worked on in terms of the provision, what's there in the framework, but as regard the practice, I found few evidence as to the scope of the implementation of these provisions to date, especially, for instance, the latest implementation report that was published over summer. But in any case, just for your information, so the TCA contains provisions in Articles 489 and 490 of the TCA to protect some social security rights of EU citizens legally residing in the member states or in the UK, and some cross-border situations. So this means that some EU citizens who work, travel, or move to the UK, and vice versa, some UK nationals who work in and travel or move to the EU, could pay social security in only one jurisdiction. So you have a protocol on social security coordination also attached to the TCA, providing for the coordination of some benefits derived from social security. But what we can observe in terms of the evolution is that there is a specialized committee on social security coordination, and it has met already 3 times, and it amended the annexes of the protocol in October 2021 to ensure that member states continue to cover workers moving to or from the UK under the social security legislation of the member state of origin. So to conclude very briefly, there are warmer relationships between the two parties, and this has favored the transition from some technical work to adopting measures at political to sustain and activate this framework for cooperation in different areas. So yesterday I heard this expression of lack of ambition, or sort of, and I think it clicked a little bit. Perhaps I would say voluntarily constrained ambition, and set from the outset this way, because there are some fields that are very essential if you think about financial services and its link with the real economy, also research and development, and how it is fundamental for education, innovation, and more broadly for society, and also mobility when we think about the social security rights. So here I would be happy also to have a broader discussion as to what was the intent. Of course, there is a rushed agreement, but leaving outside some legally binding provisions and resorting to some broader cooperation framework may allow the party to be a lot more flexible, and somehow for some key areas it could make sense for both parties. But I will leave it here, and I look forward to the discussion. Thank you.
Thanks very much, Christy, for that very interesting presentation. While the theme was cooperation, it was striking to me the extent to which this forum and the other frameworks seem to be a step back on the level of cooperation in this area pre-Brexit. And thanks for laying that out so clearly. So this brings us on to our next distinguished speaker, Professor Federico Fabbrini, who is editor of the Law Politics of Brexit series with Oxford University Press. He is also editor of this current edition of the series, Volume 5, on the Trade and Cooperation Agreement. Professor Fabbrini is a full professor of European law at the School of Law and Government of Dublin City University, where he is the director of the Law Research Centre. He is also the founding director of the DCU Brexit Institute, where he is the principal investigator of both the EU-funded Jean Monnet Network Bridge, the EU-funded Jean Monnet Centre of Excellence Rebuild, and the EU-funded Jean Monnet Module Post-Brexit Law. He's also one of the principal investigators in the Horizon Europe project Regroup. Federico Fabbrini holds a PhD in law from the EUI and is an attorney at law in Italy. Before joining DCU, he held academic positions at the University of Copenhagen and Tilburg Law School in the Netherlands. His research focuses on EU law and policy. Federico Fabbrini is the author of 4 monographs, most recently his 2022 book on EU fiscal capacity, legal integration after COVID-19 and the war in Ukraine, as well as editing a dozen other volumes. Professor Fabbrini was a fellow at Princeton University last year and a Fernand Braudel fellow at the EUI, and we're very pleased to have him back at DCU this year. Professor Fabbrini's broad research agenda in EU law and policy covers fundamental rights, economic governance, institutional design, Brexit, COVID-19, and the future of Europe. Federico, whenever you're ready, the floor is yours.
Thank you so much, Niall, for your kind and very generous introduction. And I'm really pleased to be on this panel with you and Christy. This is an old DCU Brexit Institute panel that makes me very proud. My deputies are increasingly taking over in supporting the functioning of the Institute. But of course, I want to take the opportunity, as I am the final speaker, to really thank all the other prior panelists and contributors, both for joining this conference and for participating to this book project. So my chapter to the book and my presentation this morning tries to look slightly forward by reflecting on what are the options for deepening UK cooperation in a renewing Europe. So the title is Review and Reform, mostly because I start off with the review clause that is mentioned in the TCA. I hope I can move my slides. Can you see the next slide now? Yeah, perfect. Okay, so the purpose of the contribution, which is published, by the way, as a working paper of the Brexit Institute on our website, if you want to go and check it out. The aim here is really to examine what are options for deepening EU-UK cooperation beyond the trade and cooperation agreement. And in a way, the starting point, the assumption of the whole effort, endeavor, is that, as we heard at length yesterday, but also this morning in the three presentation from Graham, Adam, and Christy, the Trading Cooperation Agreement is a very thin deal. It reflects a sovereignist logic, which the UK pushed very much during the Johnson government in its negotiation with the EU. However, this logic is increasingly at odds with a changing reality where globalization is adjusting, as we heard from Harold James yesterday, where we have new geostrategic challenges, as Daniela Schwarzer would have explained if she had been with us yesterday, but unfortunately she couldn't come. And of course, a reality where also public support for Brexit is declining. So increasingly, we see a change of mind in the British population. So if this is happening, what can be done? Are we stuck with the TCA, or are there options to go beyond it? Well, what I try to analyze in my piece is three sort of possibilities, opportunities, avenues to expand the cooperation between the European Union and the United Kingdom in the next few years. Option one is a review of the TCA, which is foreseen by the TCA itself. Option two is greater engagement between the parties in a new European governance and institutional landscape, which is largely driven by the war in Ukraine. But then, of course, there is also an option three, which is more connected with what's going on the EU side of the story. And here I'm thinking really of the constitutional reforms that are about to get going in the EU, mostly as a consequence of the revival of the enlargement process. As people will know, the European Union has promised to Ukraine and Moldova accession to the European Union, and that has generated effectively a new debate about the outlook of the EU in the next decade or so, which, as I will try to point out, has implications for the United Kingdom. So I'll go through these three options and try to point out how, in fact, we are far away from a settled status for Brexit, and the pictures remain quite dynamic still. So I'll begin with the TCA. As I mentioned, and I think probably this is a point of consensus among all authors and speakers to this conference, the current setup of the TCA is very limited. This is a very unusual FTA, free trade agreement. It's not designed to integrate the economies of the parties. It's actually designed to disintegrate the economies of the parties. And so you have plenty of provisions, and most of the speakers, particularly yesterday afternoon, including Niall, have compared the FTA with the WTO, the GATT, the Global Agreement on Trading Services, and so on. But here we are dealing in sort of damage control. And the content of the provision of the TCA, despite being extremely lengthy, ultimately reflects this reality that the two parties are getting. They are settling for a worse deal than what they had before the starting point of the negotiation. Now, cleverly, I think the TCA introduces something that some international treaties, but not many, honestly have, which is a rendezvous clause. So Article 776 of the TCA states that the parties commit to meet after 5 years from the conclusion, or actually 5 years from the entry into force of the treaties, to take stock of its application. So that means by 2026, the parties have to sit down together and sort of evaluate how the treaty has been operating in practice. And we do know, because that's made explicit elsewhere in the TCA itself, that it's absolutely possible for the EU and the UK to go beyond the TCA by concluding supplemental deals. Article 2, Article 775, and in a way, general principles of public international law confirm that the EU and the UK remain a sovereign subject of international law, and so they can conclude between themselves additional treaties. So this opens up the possibility that they might actually seek to review the TCA and add more beef to it. Now, institutionally and procedurally, The treaty creates a partnership council, which is where the parties are getting together, and partnership council has actually extensive power also to propose amendments to the treaties. Procedurally, a revision of the TCA would need to follow the constitutional rules that apply both in the United Kingdom and the European Union. So we are dealing here effectively with a fairly standard situation of international law negotiation. But what I think it's significant, because the point has been mentioned a few times during the last day and a half, is that probably we now have a window of opportunity, at least at the political level, following the UK general elections before January 2025. And the Labour opposition has already made clear, Keir Starmer delivered an interview to the FT, I think last weekend, where he said, if we win, we will seek to renegotiate the TCA. So there's, of course, elections in Europe as well, but I really think what matters here is the change on the UK side. And I think the rendezvous clause, the rendezvous moment in 2026 will provide helpful opportunities for the parties to reconsider the current state of affairs. However, beyond the TCA, and I'm moving here to the second set of developments I wanted to map in my paper, I think the war in Ukraine has generally served as a Zeitenwende for European integration in a broad sense of the term. As you know, the word Zeitenwende was used by German Chancellor Scholz in a speech at the Bundestag a few days after Russian tanks rolled over into Ukraine. And the point was to emphasize how that pushed Germany to profoundly revise its foreign policy. But beyond the German case, I think more generally, the Russian aggression of Ukraine and the return of war on the European continent has effectively re-energized the international organizations that are operating in the European continent or on a transnational scale, and in fact led to the creation of new organizations. And the UK is a key party in each of them. So one organization obviously is the Council of Europe, which is in fact the oldest post-World War II organization. It has 46 member states now, and it mostly focuses on democracy and human rights protection. The Council of Europe is the house of the European Convention on Human Rights, and it's true, we heard it from Adam earlier this morning, the ECHR remains a contested piece in UK politics. But it is interesting that in the spring this year, in May, the Council of Europe had its fourth ever Prime Minister Summit in Reykjavik, Iceland, and there was a strong commitment by all participating countries, including the UK, that the Council should serve as an organization bringing together European countries sharing the same values of respect for democracy and the rule of law. Moreover, also NATO arguably has seen a boost out of the war in Ukraine. The North Atlantic Treaty Organization was created in 1949. Again, the UK is a founding party of this. But in the last few years, particularly following the end of the Cold War, the role of NATO had started being questioned by many parties. Think of Macron's criticism of it. Putin made a major gift to NATO. NATO has now expanded. It brought in Finland and is about to include also Sweden, and generally speaking, has re-emerged as an important forum for coordinating common foreign security policy matters across European countries. And once more, the UK plays a relevant role within NATO. And then lastly, the other organization, and that's a new one that I want to mention in this slide, is this new European political community, which was created effectively a year ago in October 2022. The EPC is the brainchild of French President Emmanuel Macron, who thought we need to have something bigger than the EU to engage with the wider Europe as we wait for the enlargement to happen. And interestingly, the UK decided to play an important role in this organization. In fact, they will be hosting the 4th EPC summit in the spring of next year. So what I want to say here is basically that you now have many new or renewed forums for deepening EU-UK relations in a wider Europe. And I think that provides once more opportunities for the parties to find ways to work together. Obviously, Council of Europe, NATO, and the EPC are very different from the European Union. They don't entail the level of integration that the EU has. These are typical international organizations. There's nothing supranational in them, but still, they are frameworks in which the parties can do stuff together. However, and here's my final point, I also think we need to consider what's going on the EU side in terms of European reforms when we reflect about possible further opportunities for EU-UK cooperation beyond the TCA. Because what I think it's fair to say is that Brexit did not lead to the destruction of the EU, as many were worried about back in 2016, 2017. On the contrary, what has happened during the last 6-7 years is that the European Union has been going through a new experimental phase of reflecting about itself, expanding its powers and competencies, and indeed opening up to further enlargement. Many of you will know that the Conference on the Future of Europe was an important process for reflecting on the future of European integration, and that ended in May of 2022, so a year ago. Immediately after that, in June 2022, the European Council promised to both Ukraine and Moldova membership of the European Union, and that kicked off a new debate about enlargement. So clearly, this has implications for constitutional reforms in the European Union. In fact, the Parliament has been explicitly calling for a convention to revise the treaties, and there are multiple proposals discussed at the policy level to improve the effectiveness and the legitimacy of the European Union. Think of institutional questions like decision-making in the Council, if you have a larger union with 35 member states, but think also of substantive policy questions like the fiscal capacity of the European Union if you need to pay for the reconstruction of a country like Ukraine. So clearly there is, I think, momentum moving in the direction of treaty reforms, but there are also major challenges in that direction, which is why more and more openly discussions are being made about alternatives to enlargements, notably in the forms of associated membership to the European Union. Just a week ago, a group of 12 wise men from France and Germany published a report on navigating in the high seas, where they advanced models of concentric circles integration for the future of Europe, and as a way to phase in Ukraine into the EU. So essentially here, my point is that the future of the European Union, the future of EU-UK relations are interacting with each other, because if the prospect is one of a Europe of concentric circles, that inevitably is creating knock-on effects on the UK, but also potentially openings for the UK if it becomes more willing to re-engage with the European Union. So I'm conscious of time, and I'll wrap up in a concluding slide. What I want to say here, just as a final word, is that I think we need to be mindful of the existence of competing visions on the future of Europe. So the positive dynamics that are now existing in the relationship between the EU and the UK, also the result of the Windsor framework and the resolution of the Northern Ireland Protocol problems, should not conceal the existence of profound differences in the European and British visions of what European integration stands for. I think Harold James was hinting very clearly at this yesterday in his remark. I like to put it as a competition between a market versus a polity vision of integration. A market vision which was very strong always in the UK approach to Europe, and which is at odds with the more polity-oriented idea that has been driving the European integration for several of the continental European member states. But clearly, the war in Ukraine has been a turning point for everybody here. We are going through major political shifts, which are affecting the TCA, a treaty that was negotiated, obviously, before the return of war in the European continent. So how do we move forward from here? Of course, there's a lot of uncertainties, but I think the political way of a concentric circle Europe probably remains the most likely scenario ahead. There is pressure for countries to do stuff together. L'union fait la force, as we say, and the war in Ukraine has made that clear. But obviously, not every member state of the European continent is willing to engage with the same level of depth into integration. And that's why we have the emergence and the consolidation of alternative circuits, the EPC, the Council of Europe, NATO, and the EU itself with its inner core in the Eurozone. So I don't really have a clear answer. Obviously, I don't have a crystal ball to look in the future, but I would definitely say that the European project is going through yet another exciting experimental time, which I think is a great opportunity for us at the Brexit Institute to keep doing more research and policy work on this. So I hope this book will just be a platform to do more research on those questions moving forward. Thank you very much for your attention, and I am looking forward to the Q&A session.
Thanks very much, Federico, for that fascinating overview on the options for review and reform. So if you have any questions for either speaker, as I said, please send them to me directly or post them into the chat box, or raise your hand. So I haven't received any questions yet, so I'm going to begin with a question of my own. So, Federico, you mentioned this word of Zeitenwende, and I think that, you know, a turning point, and we have to balance the urge to enlarge the European Union with standards in relation to the rule of law and strong conditionality for accession to the EU. And we've seen how progress has been slow in this area in relation to countries acceding like Serbia and Montenegro. So I just wanted to, what do you think about how the EU should navigate this balance? Do pre-accession conditionality, do we need to tweak this in relation to the rule of law? Does it need to be strengthened or weakened? What's your sense on this?
Niall, thanks a lot for that question. I think it's a extremely important questions, and it really goes to the crux of the matter, if you will, because I think essentially you have two conflicting forces here at play. On the one hand, there is a huge geostrategic pressure for the European Union to enlarge as quickly as possible, with the sort of underlying thinking being that by expanding the EU, by bringing in new countries, the EU becomes a stabilizing force and also a stronger force of resistance against the imperialist forces in Russia. However, on the other hand, you have a very strong resistance to enlargement because we have seen the problems with the latest waves of enlargement, and because, frankly, some countries were brought into the EU perhaps too quickly, and still problems of corruptions, the inefficiency of the judiciary, and rule of law question remain. In fact, those questions would be even bigger for countries like Ukraine and Moldova. So how do you manage these conflicting needs? And I think that's why someone like French President Macron, who likes to think big, came up with the idea of the European Political Community, the EPC, as a kind of intermediate layer. The EPC allows countries that want to join the EU to already integrate in some EU policy and coordinate action in a number of domains, from energy, the environment, but also security, transport, mobility of persons, while these countries, however, also undergo profound reforms to become ready for enlargement. Now, this has to be done cleverly. You don't want to create the feeling that this is an antechamber which will not result ultimately in accession to the EU. But this logic of concentric circle I was mentioning at the tail end of my presentation is precisely designed to guarantee that level of flexibility, which I think we need in a wider but ever more diverse Europe.
Yeah, I've received a question from Peter Burke, which I'll get to in a minute. But on the question of the concentric circles, Federico, I just wanted to ask, is that only for those that don't want to integrate to the same level and to kind of have it as a holding mechanism for them? Or would it also be for newly acceded countries? So they wouldn't be fully, it might hold them back, where they might want to get full integration, if you understand my question.
Yeah, no, it's a great point, Niall. I think, this concentric circle structure would need to be flexible, and you could have countries moving in, if you will, to the deeper nucleus of integration, but also countries moving out, away from the nucleus towards the peripheral circles. The logic, of course, is that the deeper you integrate, the more you surrender your national sovereignty, and therefore the greater policy priorities you share with the others. So I was mentioning in passing the Eurozone a second ago. This is clearly a deeper layer of integration for the countries that participate to the currency union, from Ireland to France to Italy, just to mention our three home states, Niall and Christy. They decided to participate in a single currency area, which make them closer than, say, Poland, which is not part of it, or even Denmark, which has an opt-out. So those are decisions that states make, and when they make it, they of course do it consciously and willingly, and I think they get benefits most of the time out of it. But it's legitimate for countries to have different preferences, and the important point is that they know what it means not to participate in specific policy areas and the consequences of that.
Excellent, thank you. Peter, would you like to ask the question yourself, or I'm happy to, friend? Okay, great.
Hi. Well, thank you, Federico. Brilliant overview. I had two brief questions. Well, one brief question and one more complex one. The brief question is this the last chance saloon at the 5-year review, or is there going to be a further opportunity 10 years, 15 years, etc. from now? My more difficult question, perhaps, is how much scope is there for change on rules of origin and mutual recognition of qualifications?
Peter, thanks so much for your two questions. So the first one is fairly easy, and is that Article 776 creates this rendezvous, this review every 5 years. So the next one is going to be in 2026, 5 years after the entry into force, and then there will be one in 2031, I suppose. But I think it's probably too early to already think of what's going to happen in 31, because, as I say, in my opinion, this is a very dynamic moment, and things are happening very quickly. And I would not be surprised if before the next decade we would really have a new arrangement in place. I mean, just to reconnect to what I was talking about a second ago, the European Union has promised to bring Ukraine in by 2030. So that would be even before the 10 years review of the TCA. So I think let's see what's going to happen with that. Now, on your other questions, whether there are margins to reconsider, you said rules of origin, and then you were asking me.
Yeah, so rules of origin in respect of things like car batteries, which obviously have the potential to effectively wipe out the UK car industry, and mutual recognition of qualifications such as architecture and other specialties, where the UK has been an exporter of labour for many years and is now no longer so.
Yeah, I think Niall probably should answer the question on the rules of origin, because his presentation and chapter dealt with that. And my reading of what Niall wrote is that there is some optimism that might be the case, particularly given the changing geopolitical context. But I think really what would be extremely influential in determining this outcome is a victory of labor and a much more clear position by the new government that it wants to, seek regulatory realignment with the European Union in some areas. That would definitely make it easier to have mutual recognition of professional qualification, among others, and possibly, mutual recognition of financial supervisions and so on and so forth. But maybe, Niall, you want to jump in, and I think the mutual recognition bit is connected to equivalence. So perhaps, Christy, you want to say more too.
Sure. Yeah, for improvement on rules of origin, I think the simple proposal to extend the transition deadlines at the minute is very doable. Commissioner Breton has said that they're not envisaging it at the minute, but Germany, industry, and the UK have come out in support of it. And I made the point yesterday that, I think it could be delayed, but where both sides agree. In terms of a more long-term solution, I pointed to yesterday in my presentation that kind of depends on the UK joining the PEM Convention. If it wants to have, diagonal accumulation stay in EU supply chains, and I think it's also important for the EV industry. So that would be my answer on that one. Christy, do you want to answer the second part on mutual recognition?
Yeah, well, thanks. I haven't really focused on mutual recognition in this piece, more areas of cooperation in the context of the joint regulatory forum. So sort of, it's not as integrated. But one thing I wanted perhaps to elaborate on, and I'm taking it from the previous panel, which is autonomous adaptation. So this notion that Adam referred to, and somehow which would lead us to be a little bit more constructive about some areas where there can be constructive cooperation. So we go at the level where from exchanges of views, exchanges of information, perhaps even best practices over forums that are multi-layered, etc. You would have this development happening. And I see that happening in the field of financial services.
Thanks very much, Christy. So we have a couple of questions that have come in. The first one is from Tony Cox. Tony, if you'd like to read it, or else I can read it out. So Tony asked, what is the appetite within the EU to engage with the UK on discussing a route back to full membership? So maybe Federico, I can start with you on that one.
So the question is whether the EU would be open to bring the UK back in, I guess, Tony.
Is there an appetite, to engage on this question?
Well, I'll start with the UK side. I'm not sure there's an appetite on the by the UK to go back into the European Union. So this is why in my paper I've been thinking mostly at options which are alternatives to rejoining. Technically speaking, under Article 49, it's always possible for in fact, under Article 50, it's always possible for a country that left the EU to rejoin the EU afterwards. And I think the EU would probably be open to discussing this with lots of conditions. But I really think this is not a non-starter, because even the Labour government is not advocating rejoining the EU. So what in my opinion is going to be the focus of the conversation in the next couple of years is really opportunities for deepening this cooperation through new forums, or through a reform of the TCA, or possibly, if the EU itself changes profoundly, then in one of these tiers of associated membership.
Thanks, Federico. So I believe there's a question from Martin Allen. Martin, would you like to ask your question? And
we can turn off your mic and video, Martin, as well.
Yeah. I'm trying to unmute.
Hi, Martin. Yeah, I think we can hear you now.
Hello. Can you hear me?
We can hear you.
Yes.
I'm a lay person. I'm not a student. My background's construction in terms of academia. But I feel that there's an imbalance of membership in the EU and its responsibility to be a peaceful organisation. It's currently involved in several different issues, which my understanding it never had a remit with or for in the first place. So you've mentioned Ukraine. Why is European Union paying for Ukraine if Ukraine isn't not a member of the European Union?
Thanks, Martin, for that question. So I think you're raising probably two questions at the same time. One is about the remit of the EU, and I think the other is about Ukraine more specifically. So on the remit bit, what I would say is that definitely the European Union, in response to a almost never-ending series of crises, has largely expanded its remit over the last few years. And interestingly, this was always done with the unanimous agreement of the member states, which are represented in the Council of the EU. So think of the responses to the pandemic. The European Union doesn't really have competence on health. It's not in the treaties, but the member state unanimously agreed to actually delegate to the Commission the task of purchasing vaccines. Or think of the sort of the economic slump resulting from COVID-19. Again, the EU has a very limited budget, but the member state unanimously agreed to give to the European Union powers to levy resources on the financial markets and transfer this money to the member states as grants and loans through the Next Generation EU Recovery Fund. Now, Ukraine is similar. The war obviously was a shock. The EU doesn't really have any military competence. This is mostly for NATO, for the member states which are party of NATO, 32 countries today in NATO. But in response to the war, again, states decided to coordinate within the European Union and provide military and financial support to a country that is being under attack elsewhere. Now, when I was mentioning the cost of enlarging to Ukraine, I wanted to point out that if Ukraine becomes a member, it's going to be extremely expensive to pay for its reconstruction, pay for rebuilding all its infrastructure and so on and so forth. But we will have to see whether that happens or not.
Thanks, Federico. So I have a question for Christy on regulatory cooperation. It's an area that interests me. I think that we have to avoid divergence, or at least be conscious that it's happening, and forums like the one you mentioned can really help. But there is a feeling that a deal that is heavy on goods and light on services helps the EU to some extent, particularly in the area of financial services where the UK has been so strong. So do you think that the EU will extend the expiration dates on simplified access for UK service providers in the area of financial services? And is there much of an incentive for the EU to do this, to encourage cooperation and to facilitate simplified access to the single market in financial services?
Thanks for your question. So I think we cannot avoid divergence because it's happening. I mean, actively or passively, perhaps for now passively in this field. There will be this forum facilitating discussion, but there are definitely some areas of financial services where there will be divergence. If it's medium, high, I discussed that with my co-author, Torsten Beck, in a report for the European Parliament. We need to observe the developments of legislation on both sides of the channels. But there is divergence, definitely. And this is this is just a given outcome of the situation. Then as regards extension, being constructive, giving more grounds and facilitating some activities and financial services, etc. I would say it depends very much on what will be going on in the first two forums, perhaps the first forum and then the follow-ups. Because at the same time, what's going on both sides, it's a strong emphasis on competitiveness. So in the financial services sector on the UK side, now there is even as part of the secondary mandate of the regulators, growth and competitiveness. So this is for the UK side. And then on the EU side, we have different files, different legislative initiatives to strengthen this sector, to strengthen the capital markets union, to make sure that we have also clearing being a little bit more strong with all the infrastructure, supervisory and regulatory frameworks, and so on and so forth. So I see some constructive approach. Then it's difficult to predict because, I mean, I don't have a crystal ball. What I can say is from the discussions leading to the signature of the MOU, from the preparation work that is put into the regulatory forums, there is leeway for that, for constructive approach and facilitating the cooperation for the industry. But at the same time, we need to be aware of this competitiveness element, which is part of which is key and core to the real economy of both sides, and they are autonomous in this respect.
Excellent. Thanks very much for that very complete answer, Christy. So I don't see any further questions unless anyone wants to put up their hand. But if not, I think that brings us to an end on this fourth panel on process and prospects. So all that's left is to thank the speakers for the very interesting presentations and for answering the questions so well. And thanks to everyone who has joined us here this morning. Federico, do you have any final message?
No, I just wanted to thank you, Niall, as well for chairing the panel. And of course, Christy, once more for speaking here. And thanks to all the other speakers for their great papers and contributions. So I will be shortly in touch with you all for the final details towards the publication. And again, for the audience, just to remind you that the proceedings will be published as a book, The Law and Politics of Brexit, Volume 5, the Trade and Cooperation Agreement, coming out with Oxford University Press next spring. So be on the lookout for that. And remember that there are 4 other volumes that we have already published, and they are all available also in paperback. So thanks again for all your attention, and have a nice weekend.
Thank you.
Thank you.